Today, we are diving into one of the most fascinating corners of criminal law. We're asking, how is it possible for someone to commit a crime, admit they did it, and still walk away not guilty? I know, it sounds like a total contradiction, but it's a really important part of our justice system.
So let's just put the main question right out there. Can you actually commit a crime and not be held responsible for it? And the answer, which might surprise you, is yeah, sometimes. The key to understanding how that's even possible lies in a legal concept called excuse defenses.
Okay, before we get any further, we have to draw a super important line in the sand between two big ideas, justification and excuse. A justification, think self-defense, is basically arguing, you know what, given the circumstances, what I did was actually the right thing to do. But an excuse defense says something totally different. It says, yeah, what I did was wrong, absolutely, but you can't blame me for it. You see the difference? It's all about separating the bad act from a blameworthy person.
All right, so here's the plan. First, we're going to dig into that core idea of being guilty but excused. Then, we'll look at cases where someone was basically forced to commit a crime. After that, we'll talk about defenses based on impaired judgment, and then we'll tackle the big one, the super famous and super misunderstood insanity defense. And finally, we'll touch on a few wild, creative defenses that really push the legal limits.
So let's unpack this whole guilty but excused thing. You know, the law kind of assumes that we're all captains of our own ship, right? That we're making free, rational choices. But what happens if someone else hijacks that ship? Or a massive storm just throws it completely off course? Well, when that free will, that choice, is taken away, the law might just step in and say, okay, the ship crashed, but we can't really blame the captain for it.
And that leads us perfectly into our first group of excuses, situations where your choice isn't really your own because of some massive outside pressure. This is where the law looks at forces that are completely external to the person and asks, did they really have a choice?
And the classic example here is duress, the whole gun to your head scenario. Duress is a defense where you argue, look, I only did this because I was facing an immediate threat of being killed or seriously hurt, or maybe my family was if I didn't do it. Your will was just completely overpowered by the threat.
But here's the thing. Actually winning a duress claim is incredibly tough. The legal bar is set sky high. First, it can't be some vague threat down the road. The law says it has to be immediate and severe. Second, your fear has to be real, something any reasonable person would feel in that same spot. And third, and this is often the hardest part to prove, you had absolutely no reasonable way out. You couldn't run, you couldn't call the police, you were completely trapped.
Now, another one in this category is entrapment. And this one is pretty unique because it flips the script and puts the government's actions on trial. The big question here is, did law enforcement just give someone the opportunity to commit a crime they were already planning to do, or did they go way further and actually plant the idea, basically creating a criminal out of someone who wouldn't have done it otherwise?
So we've talked about external forces. Now let's shift gears and look inward, at the defendant's actual state of mind. This next set of defenses is all about those moments when a person's judgment was so clouded that in the eyes of the law, they couldn't have truly intended to commit the crime. So, can being drunk or high get you off the hook? Well, the classic legal answer applies here. It depends. If you chose to get wasted, that's voluntary intoxication, the law is probably going to say, tough luck, you're responsible. But what if someone drugged you without you knowing it? That's involuntary intoxication. And in that case, because you never chose to be impaired, you might actually have a real excuse. Age is another really big factor here. For centuries, the law has recognized that a kid's brain just doesn't work like an adult's. Under the old common law rules, it was broken down into these really clear stages. If you were under 7, you were considered legally incapable of committing a crime, period. Between 7 and 14, the law assumed you were incapable, but the prosecution could try to prove otherwise. And then, once you hit 14, you were generally treated as being old enough to form criminal intent.
Okay, it's time for the one everybody's heard of, the insanity defense. Thanks to a million movies and TV shows, it's easily the most famous legal defense out there. But it's also, by far, the most misunderstood, and it's almost never successful.
And if you remember one thing from this whole explainer, please let it be this. A person can have a very real, very severe, medically diagnosed mental illness and still be considered legally sane in a courtroom. Why? Because insanity in this context is a legal standard, not a medical one. It's a decision made by a judge or jury, not a doctor.
So how does a court even begin to figure this out? Well, there's no single rule. Different states use different tests. The oldest and most famous is the McNaughton test. It's basically a simple right-wrong test. Did the defendant know what they were doing was wrong? Other places use a broader test, like the MPC test, which asks if the person was even able to control their actions. They're just different legal tools trying to get at the same fundamental question. Was this person's mind so fundamentally broken at the moment of the crime that we just can't hold them responsible?
All right, for our last section, let's take a quick look at some defenses that go way beyond the standard textbook stuff. These are the ones that are often really controversial and show just how far lawyers will go to push the boundaries of what we, as a society, are willing to excuse.
I bet you've heard of some of these. The famous Twinkie defense, for example. It was never really about the Twinkies. The real argument was that the defendant's junk food diet was a symptom of a deep depression that impaired his judgment. Or more recently, the affluenza defense, which argued a rich kid was so spoiled he literally couldn't understand that his actions had consequences. Now, these defenses almost never work, but they're fascinating because they show this constant push and pull over what it means to be truly responsible for your actions.
And that really brings us right back to the core idea of this entire topic, which this quote just nails. Excuse defenses, they don't pretend a bad thing didn't happen. Of course it did. What they do is they force the legal system to wrestle with a much deeper moral question. Can we actually blame the person who did it? So I'll leave you with this to think about. Society, through our laws, has to draw a line somewhere between a bad act and a person we can truly blame for it. After everything we've talked about, from duress to intoxication to insanity, where do you think that line should be drawn?